The next case that I'm going to call Forrest Wenis. Good afternoon.
Good afternoon, ma'am.
This is case 3A01505558. And sir, you are charged with 1 count of driving under the influence and 1 count of operating a vehicle without an ignition interlock device. Both of those charges are gross misdemeanors, punishable by up to 364 days in jail and or a $5,000 fine. Oh, I'm sorry, just one moment. It looks like this one was filed as a felony.
It is, Your Honor. And what we planned on doing was I had to get a hold of the trooper and get a hold of all of his criminal history this morning. And once I realized how bad it was and how dangerous he was, I wanted to get the charges rolling right now. Our intent is to file the felony charge or bind over the felony charge and have it heard, not this Friday because we don't have enough time, but next Friday. Unless somebody could disprove the convictions we've found, there's no way that this does not end up as a felony in 2 Fridays from now.
Okay, thank you for that explanation, Mr. Ashcraft. What that means, Mr. Wanis, is the driving under the influence charge is a felony punishable by up to 10 years imprisonment and or a $10,000 fine. The alleged incident happened on or about March 7th, 2023 in Jefferson County, Washington. And sir, you should have received a document from jail staff called Acknowledgement of Defendant's Rights. Did you receive that form?
Yes, ma'am.
And did you have a chance to review that, or would you like me to go over that with you?
I looked at it now, thank you. Excuse me, I'm just devastated.
Okay. Do you have any questions about the rights that you have?
No, ma'am, not.
And Mr. Davies is in the courtroom to represent you for purposes of today's hearing. I've read the probable cause statement that's associated with your allegations, Mr. Davies.
So, Judge, I've been doing this a long time, but I think it's the first time I've ever had a case filed here as a felon. So, is it we're treating it as an initial appearance, and the plea would be made over in Superior Court?
It's essentially an initial appearance. There's a 30-day period in which we have to file charges across the hall. And this does not count towards a speedy. Speedy starts when it's filed. I mean, speedy's ticking here, but speedy over there starts when we file it.
So I don't think there's any harm in entering a not guilty plea, even if it's a little premature, and we'll argue conditions of release.
Okay. I'll find probable cause and enter pleas of not guilty. Mr. Ashcraft?
Your Honor, looking at his criminal history, so from his triple I was able to find he has a 1990 DUI that has no disposition out of Oregon. Then in Oregon, these are all convictions. He has a 2003, 2005, 2014, 2015, 2019 DUI. And then in Washington, he has a 2017 conviction, and he's currently on a deferred prosecution on a 2016 deferred that appears to still be active. I saw docket notes from a couple, I believe last year, where it appeared there have been several violations in the extended jurisdiction, but then that's as far as I got into. It appears it's still an active deferred prosecution, though, that it hasn't been revoked and that he hasn't reached the end of it. In any event, it would count as a conviction for the purposes of a felony DUI. So he has 5 and 10 years, when 3 is what is needed for the felony. He's only got a couple of warrants. But looking at the docket notes, it looks like he wasn't always compliant, that he had probation violations on the deferred prosecution in, what county was it? It was in Eastern Washington. I forgot which county it was. And also I was speaking to probation, and they had noted that it appears he'd had violations out of Oregon because they have access to a system that I don't have. Then you look at the facts of the case where he drives into a state park and just walks up to the ranger. He drives into the state park drunk, walks up to the ranger drunk, and then walks away. And at that point, the ranger stops him because he's afraid for the community. We think he is absolutely a danger to the community. He has only got 2 warrants, so it appears he does show up. but it does not appear there's any way to stop him from drinking. He's supposed to have an ignition interlock in his car, and he didn't. So we're asking for the bail in the amount of $200,000. That if he posts that bail, he needs to appear next Friday in Superior Court, and that's when the felony charges will be filed. Then we're asking for all the other standard DUI conditions. Don't break the law, keep the court up to date about his address. He's already supposed to have an ignition interlock, so we'd ask that he have an ignition interlock on his vehicle within 72 hours of release. He's already supposed to have one. So giving him extra time, it just seems dangerous at this point. He's got to have license and insurance if he's going to drive. No drugs, no alcohol, no marijuana. Don't go to places where those items are the chief item of sale. And report to probation upon his release, and then as directed by probation. And that's all we're asking for at this point.
Mr. Davies.
So Judge, of reserve with respect to conditions of release, including bail, what Mr. Ashcraft has stated here isn't reflected in anything that I've been furnished. And so we could perhaps readdress it if we should note it up prior to the hearing in Superior Court. It'd be readdressed there in Superior Court next Friday.
Okay, thank you. Based on that, I will go along with the conditions of release as outlined by Mr. Ashcraft. However, instead of the ignition interlock device, I'm going to order that Mr. Runnus not drive at all. That means you are not to be behind the wheel of any vehicle whatsoever. Your bail will be $200,000. You are to appear next Friday, or not this Friday, but the following Friday, right? The 17th?
The 17th, yes, Your Honor.
Appear March 17th at 8:30 in Superior Court. In the meantime, you are not to have any criminal law violations. You are not to use or possess alcohol, non-prescribed drugs, and that includes marijuana. You are not to go to places where those items are the chief item of sale. So no bars, taverns, casinos, liquor, or cannabis stores. And you are not to refuse a breath, blood, or urine test if one is requested of you. You are to report to probation the next business day if you are able to make bail. Anything further, Mr. Ashcraft?
No, Your Honor.
And because he's in custody in this particular case, I will appoint Jefferson Associated Counsel to represent you. You can always go and hire your own attorney if you would rather.